For a second time, PragerU, the folks who tell you that you shouldn't run to the government to force a private company to not discriminate against you, has tried and failed to get the government to force YouTube not to discriminate against them. The Ninth Circuit Court of Appeals released its ruling on PragerU's lawsuit against YouTube. Again, PragerU has tried to argue that YouTube, putting a few PragerU videos into a category that makes them inaccessible if you use YouTube in restricted mode, violates the First Amendment. And again, the court has told them that YouTube is a private company, which means that they are not subject to the First Amendment. Now, I have to address something that will inevitably come up in the comments because it always does. An argument that I frequently hear from defenders of PragerU, and an argument so inept that even PragerU has never tried to use it in its several attempts to sue YouTube, although it did make this argument in a video, is that YouTube is a platform or a public forum, not a publisher, and that means that it cannot exercise any editorial discretion with respect to legal content uploaded to the website.
Wait a second, you might say. YouTube, which is owned by Google, is a private company. Can't they do anything they want? The answer is yes and no. Yes, if they are a publisher. No, if they are a public forum. A few years ago, the social media giants, Google, Facebook, YouTube, and Twitter, started to behave not like public forums, but like publishers. They stopped following Section 230, which specifically requires that these websites promote a true diversity of political discourse, and began to judge content by their own political and social criteria.
Lots of people have latched onto this idea that YouTube legally must be ideologically neutral if it doesn't want to be treated like a publisher. This is false. Many years ago, Section 230 of the Communications Decency Act was passed to protect internet forums from being sued for statements uploaded to them. If a publisher, like say Random House, publishes a book with defamatory statements in it, not only can the defamed person sue the author, they can also sue the publisher, because the publisher exercises total editorial control over everything it releases. Some PragerU defenders believe that if a company does not want to be held to the same standards of liability as a publisher, they legally cannot censor any legal content on their platforms. This is just not the case. In fact, the CDA explicitly protects companies' abilities to exercise some editorial control without holding them to the same standard as a publisher, which exercises total editorial control. The bit about true diversity of political discourse is part of the findings section of the law. This is the section that outlines the premises on which policy is based, not the policies themselves. The law places no obligation on any website to maintain true diversity of political discourse. This is just a description of what Congress finds that many websites already do, not a prescription of what they must do. In the actual policy section of the law, it says that the point of the law is to encourage the development of technologies which maximize user control over what information is received by individuals, families, and schools. PragerU is complaining about YouTube placing some of their videos in restricted mode, but the fact that YouTube has a restricted mode and places some videos into it is precisely the kind of technology that maximizes user control that Section 230 of the CDA explicitly encourages. The law also aims to remove disincentives for the development and utilization of blocking and filtering technologies. Civil liability, for example allowing people to sue for First Amendment violations, is precisely the kind of disincentive the law aims to remove. It says that no provider shall be held liable for removing content it finds to be objectionable. PragerU defenders claim that the CDA says you're not allowed to censor if you are a public forum or a platform rather than a publisher. But it actually says the exact opposite. It explicitly protects the ability of these platforms to censor without being held to the same standards as a publisher. And again, this is not even an argument that PragerU is using in court. I think they know that the CDA protects YouTube, not PragerU. However, the argument they are using is almost as silly. PragerU claims YouTube's outsized power to moderate user content is a threat to the fair dissemination of conservative viewpoints and perspectives on public issues, and that YouTube has become a public forum. The courts have all disagreed. As the Ninth Circuit said, just last year the Supreme Court held that merely hosting speech by others is not a traditional exclusive public function and does not alone transform private entities into state actors subject to First Amendment constraints. There's another argument that PragerU tried to use, which is that YouTube is guilty of false advertising, because it claims that YouTube says that it is committed to free speech. The Ninth Circuit says, YouTube's braggadocio about its commitments to free speech constitutes opinions that are not subject to the Lanham Act, the law against false advertising. Lofty but vague statements like, everyone deserves to have a voice, and that the world is a better place when we listen, share, and build community through our stories, or that YouTube believes that people should be able to speak freely, share opinions, foster open dialogue, and that creative freedom leads to new voices, formats, and possibilities are classic non-actionable opinions or puffery. Those statements aren't even promises that YouTube will protect free speech. All they say is, free speech is totally awesome, not that YouTube is actually going to grant it. They don't even make these statements in their advertising, but rather in their description of the content moderation process. The court said YouTube's statements concerning its content moderation policies do not constitute commercial advertising or promotion as the Lanham Act requires. The arguments that PragerU used are so weak that it's hard to believe that even they expected them to convince a court. This seems to me to be a publicity stunt, and PragerU is already bragging about the fact that it's working. PragerU released this video doing a victory lap, despite the fact that, in the courts at least, they didn't have a victory. That's because their real victory was in wasting the judicial system's time and taxpayers' money in order to get into the headlines. Conservatives often complain about professional victimhood and virtue signaling. But if this isn't trying to profit off of being victimized by YouTube and trying to convince people what free speech warriors they are, I don't know what would be. But you can't expect an organization like PragerU to engage honestly with reality. Dennis Prager, the guy in charge of PragerU, says he believes that if you always doubt a leftist claim, you will almost always be closer to the truth. I employed that rule in concluding the collusion story was a fraud, and it served me well. Ever since I attended college, I have been convinced that either studies confirm what common sense suggests or that they are mistaken. In other words, Prager automatically assumes that any evidence contrary to his prejudices is illusory. To Prager, reality is merely what his prejudices tell him is real, not what your own lying eyes tell you. To everyone who helps me out on Patreon, you're a big help. Thanks so much.